26, paragraph 26, broker disclaimer. This is where your broker or your real estate agent or the person may not be serving you as an agent. But in any case, regardless of their capacity, they are making no warranties or representations of any kind. And it goes through and lists a whole bunch of stuff. Condition of the property, the water, the waste, the air quality, the HVAC, off-site conditions, on-site conditions, schools, title issues. None of those things are they offering you any kind of warranty or representation, express or implied. It's one of those huge disclaimers. It probably also serves as a pretty good list, buyer, of things for you to investigate. If these things should be interesting to you, that you may want to look into. Now, the last sentence of this paragraph gives me great pause. The first part of it is fine. Parties consent that their brokers may communicate with them via any means. That means you're allowing them to text to you, you're allowing them to email to you, you're allowing them to call you. The last part is one that concerns me, and I don't think that most realtors are going to rely on. And it says that you, by signing this contract, that y'all are agreeing that your brokers may use or disclose information not made confidential by written instruction of the parties. What that means in English, and not legalese, is that unless you hand to your realtor a list of things that they must keep confidential, they don't have to keep things confidential. Okay? I would think most realtors would be going like this, what? At this point, because realtors all know that the law is that they owe you a duty of confidentiality. It can be as you being an agent for you and you being their client and they owe you all of this confidentiality. Or it could be that you are just their customer, but they still owe you a limited duty of confidentiality. It says that they'll preserve confidential information unless granted written consent to disclose the information. And there's all through licensing law, ethics, just common sense of agency, that you cannot disclose information that's confidential under the law or under ethics or under just, like I said, basic agency agreement where I'm a power of attorney for someone type agency agreement. You are the principal, they're the agent, they maintain your confidentiality. So hopefully your realtor will not abide by this paragraph, but it is one of great concern to me. Certainly, they can disclose confidential information if you've give them consent, but that consent should be in writing and it should be informed consent. And burying this down here in a broker disclaimer for that to be a valid waiver of confidentiality. And guys, this is really important. I mean, what if the seller, if I'm your agent and I say, unless you tell me in writing not to, I can tell them that you'll take $10,000 less than the asking price. I just don't think it's there. I certainly, if I were doing the contract, would mark it out. But you know, I'm an attorney. I am not your attorney. So you ask your attorney. But that's just my legal opinion of what that paragraph means.